Hello there, woven web enthusiasts. Today we have a story that comes out of an actual court report from Rockbridge County Circuit Court, Tanson v. Radulescu. It's written by Judge George E. Hauntz III. He writes, on June 3, 1994, this court, sitting in Fincastle, Virginia, heard arguments, and I'm going to paraphrase here, from the complainant, Richard Tanson, to deny Edward Strasik's motion to intervene in this proceeding, and two, to preclude Dominika Radulescu from assertion of non-paternity. This cause comes on an appeal from the order of the Juvenile Domestic Relations Court of Rockbridge County, granting joint custody of the child, Alexander, to Tanson and Dominika. Subsequently, a divorce action has been filed between Tanson and Dominika, which is also pending in this court. And now the court gets into the story. Tanson and Dominika were married some years ago in Chicago, Illinois. Dominika had fled Romania for Italy and eventually gained entry into the United States, where she completed her advanced education, which she had begun in Romania. Tanson, because of treatment for a serious illness, was unable to complete his advanced degrees. The treatment of that illness also left him sterile. Tanson and Dominika met, courted, and married. Dominika knew at the time of the marriage that Tanson was sterile. Something over 5 years ago, Dominika had a liaison with Edward. Whether the relation was an adulterous affair in the classic sense of that term, of an effort on her part to become pregnant, is a matter of further proof. In either event, Dominika became pregnant. Edward did not know at the time he was the father of the child. Tanson, for obvious reasons, was upset by the pregnancy, but through counseling and reflection came to accept the fact and, when the child, Alexander, was born, came to accept the child. In oral argument, it was conceded that Tanson and the child have bonded. At or about the time Dominika was offered a position as a teacher of the French language at Washington Lee University, she became pregnant again, this time by someone other than Edward. Tanson apparently reluctantly followed his wife to Virginia. Tanson found employment at the University of Virginia, and the parties separated. The custody petition and the divorce action ensued. We address these issues in the context of the appeal of the custody determination made in the Rockbridge County Juvenile and Domestic Relations Court. Dominika first asserted non-paternity in the juvenile court action in Rockbridge County. When Edward became fully aware he was the father of the child is subject to further proof. In any event, he clearly learned he was the father when he was ordered by the Juvenile and Domestic Relations Court of Rockbridge County to submit to DNA testing, the results of which established with 98.8% certainty he is, in fact, Alexander's father. Upon learning of his paternity, he petitioned to intervene in the custody action, and his intervention was denied. And skipping forward to get to the relevant parts in regards to just the story of this case, the court continues. In the limited evidence and representations now before the court, we find Edward had reason to suspect he might be Alexander's father. That assumes a union between Dominika and Edward, which has not been denied. What is not before us is whether Edward knew or should have known Tanson was sterile. If he did know Tanson was sterile, then there are moral and practical reasons for his not asserting paternity earlier. The wife's lover confronting her husband with his paternity of a child is not something either practical or pleasant to contemplate. Such an allegation, absent particular known circumstances, would be potentially devastating to all concerned. We only know at this point that Edward's suspicions were enhanced by and confirmed by a court-ordered blood test. Confronted with the results of that test, Edward came forward to assert his claims in the proceeding. And to briefly summarize the decision of the judge, the biological father of the child, Edwards, he was denied any action or access to the child. If you'd like to read this case in its entirety, I have it on my Patreon page for free, a link to which is in the description. If you have any thoughts on this case, let us know in the comments, and I appreciate you listening.